Good morning. I am Aaron Blumberg, Swiftland's Continuing Education Coordinator, and it is my pleasure to welcome you to Copyright and Digital Libraries. We have a wonderful learning opportunity ready for you this morning with Katie McCormick. Katie McCormick is the Associate Dean of Libraries for Special Collections and Archives at the Florida State University. In this capacity, she manages the rare book, manuscript, and archival collections of FSU, as well as cataloging and the Digital Library Center. She is a member of the Florida DPLA Service Hub Planning Group. She has served as the co-chair of the Florida Virtual Campus Digital Initiative Subcommittee and as a member of the Florida Statewide Digital Action Plan Steering Committee. She previously served on the advisory board for North Carolina Exploring Cultural Heritage Online. Her professional interests include community engagement, copyright and intellectual property, digital access, preservation, audiovisual archiving, and teaching. She holds an MLIS from Simmons College and a master's in English with a focus in Irish literature and culture from Boston College. Please welcome Katie and enjoy her webinar this morning. Katie?
Good morning. Thank you, Aaron, for that nice introduction. Can everyone hear me okay? Is my volume good? I always like to double check that even as I come in. Well, welcome everybody. Thanks for being here this morning. As Aaron said, our topic today is copyright and digital libraries. We've got about an hour. I've got a ton of information and a lot of slides. So I'll work through these and try to leave some time at the end of the webinar if there are questions. I will also do my best to keep an eye on the chat box. So feel free if there are questions that come up as I'm going through the material to type those questions into the chat box. And I'll be happy to pause for a moment and try to answer those questions. Or if I know that it'll be coming up, I'll recognize that, and we'll try to get to everybody's to make this webinar as useful to everyone as possible. So a few goals today. We're going to start by reviewing a few copyright basics. I think even if you've done a lot of copyright webinars or learning sessions, it's always good to go back to the basics as a framework for discussions. And then we'll go from there to try to develop a framework that will help us assess copyright status of material that we'd like to digitize or that we want to know how to even select material based on its copyright status. And at the end of the webinar, we'll spend a little bit of time talking about once you've chosen material to digitize, you've assessed that copyright, we'll talk about the importance of strategies for creating useful rights and access statements in your metadata. So once you know the copyright status of material you've put online, really being able to advocate and help your users immediately understand what it is that they can do. And we'll talk about some new things that have come up and been developed in the last couple of years that help do that. I'll always throw in a couple of caveats when talking about copyright. One, I'm not a lawyer, I'm not trained, I don't have a JD. I've done a lot of workshops and educational sessions, and having been engaged in digital collections for close to 13 years now, I've just gained a lot of experience over time. I start with that caveat because copyright is about the law, and there may be ins or outs that your institutional counsel or your institution's contract lawyer may have a different opinion on, and those are always important to listen to as well. The other caveat, I think copyright, like many things in our profession, there's no single perfect strategy. It would be awesome if in assessing copyright status and moving through these frameworks that there were multiple clear definitive answers, but a lot of times there aren't, and it's a matter of sort of triangulating information, assessing risk, and moving forward with the best possible information that you have. So with those goals and caveats in mind, let's get started. So what is copyright? It's exclusive right legal right given to an originator or an assignee to print, publish, perform, film, and record literary, artistic, or musical material, and to authorize others to do the same. That is the definition from the copyright statutes. What does that mean? Really, copyright law is about balancing the protection of creators with the public interest in access. Um, copyright law terms, so those periods of protection for material do change. The amount of time it's protected and when it's released to the public can vary. Copyright law has been re-legislated several times. This is part of what makes it confusing. We'll talk about some of the ins and outs of current copyright law, and as we do that, you'll see that different chunks of time or different lengths of time may have different implications. I sort of think about copyright in a kind of triangulated balance of interests. So it's there to balance the interests of those authors, creators, and publishers, but also balance the interests of users within that frame. So while authors and creators have certain rights designed to protect their work, helping to ensure creation of intellectual work and the ability of people to make a living on that work, these parameters can sometimes present restrictions on whether something can be digitized and shared on the open web. Sometimes authors and creators sign over their rights to publishers through contracts or other legal documents, and the publishers become the one who hold those rights. Those term limits and those variations in periods in copyright terms are really about also protecting the public. So that in the history of copyright, it was never the intention that material would be in a perpetually restricted zone. That the ability of users to take and build on ideas, to share creative works, has always been a part of the equation. One of the things beyond those term protections and those limits to protect authors, creators, and in our current day publishers, fair use comes into that, so that in users having fair use rights, we can create transformative works from material even in copyright, as well as looking for that moment in time when copyright protections end and material goes into the public domain. These are important things to keep in mind as we move through thinking about selection of material or assessing material for digitization. Cultural heritage institutions, in our work to determine whether we can legally digitize material, but also what the level of risk for digitized contents may pose, copyright status really helps us figure that out. On the part of the user and our users, sharing copyright status and being as explicit as we can about what we know about the nature of copyright of the material we've digitized can help users determine what they can and cannot do with digitized content. It's important also, I think, as we move through this, in recognizing, I know within my own organization and in other organizations that I've worked with, and as I've talked with people around the state and around the country, I know that copyright status, particularly related to putting material online, can come with a bit of anxiety. That the being able to assess the level of risk that your institution is willing to accept can be a difficult process. And so moving through these stages and thinking about not just what the legal ramifications of copyright status are, but also sort of what role cultural heritage institutions play in sharing cultural information can be a good way to position conversations if anxiety is high in your institution. So where do we start? In digitization projects, the first and best space to start is selecting material that's already in the public domain. The public domain, as you may be familiar with, is when intellectual property rights of works have expired, they've been forfeited, or they're inapplicable, or when copyright simply doesn't apply to the work. I think it's incredibly important to know that when works are in the public domain, they may be used freely and without attribution per the law. I think I'll pause for a moment on that particular concept because it's an incredibly important concept to understand. That when we digitize, and particularly when we digitize public domain material, we don't have any restrictions in how we can digitize that. We shouldn't be concerned about the risk that we can material we can identify as in the public domain. We should feel free to share that material digitally and as broadly as possible. But it also means to a great extent that our digitization of public domain materials is a public service. Once we put public domain items online, users should be free to use that material in the full context and power of the public domain. It's considered good practice for our users to attribute public domain materials, to say where it came from, but there's no requirement for that under the law. And we can talk later about sort of all of the thoughts and concerns that that concept brings up, but I think it's a good framing place when we talk about sharing public domain material and helping to, as cultural heritage institutions, helping to really affirm and carry forward that concept. So with the public domain, there are 5 common ways that a work transfers into the public domain. 1, the copyright has expired. 2, the copyright owner published the work without a copyright notice. 3, the copyright owner failed to renew copyright status. Those 2 and 3 are particularly pertinent to specific periods of time. 4, the copyright owner deliberately places or dedicates material to the public domain using Creative Commons licensing, zero dedication. Or the copyright law does not protect this type of work. As we go through the presentation, I'm going to mention Creative Commons licensing. We don't have time today for me to go into the broad details of that, but I'm also always happy to provide some references to the greater details of Creative Commons licensing. But to start, we'll just talk through each of these stages. Number 1, has the copyright expired? Items published before 1923 are public domain materials. That in some ways is an easy enough concept. We use this here at FSU as a guiding principle when we're looking for digitization projects that we want to start quickly and easily. Is it published? Was it published before 1923? Has anyone else digitized this material? If the first 2 answers are yes and the last answer is no, we like to move forward with that. One sort of complication or sort of I think not really a complication, but something that can open our parameters in thinking about what was published before 1923 is that under copyright law, published means more than what we might think. That publication is the distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership, or by rental, lease, or lending. The offering to distribute copies or phonorecords to a group of persons for purposes for further distribution, public performance, or public display constitutes publication. Generally, publication occurs on the date which copies of the work were first distributed to the public, so that subsequent distribution dates are important or can be important to know, but it really is that first distribution. I think we generally think of publication as applying to items with specific publishers like books, journals, newspapers, but this definition is broader based on that distribution factor under copyright law. So you might see sort of consider some of these examples: books, posters, brochures, pamphlets as published materials, correspondence, journals, diaries, most or many photographs as unpublished materials. Items like posters and brochures that may be created and then distributed to the public broadly are considered published. Photographs, there are times when photographs may also be published entities if they were published, say, in a magazine or a newspaper. But most photographs, certainly in our collections or archival collections that we find are really personal photographs as opposed to those with distribution. The copyright law really offers the most protection for unpublished material, especially creative materials. So anything published after 1923 or anything, sorry, excuse me, anything published before 1923 falls into the public domain. But as you can see from this snippet from Cornell's copyright term and the public domain in the United States, that unpublished work has a broader and longer copyright term. If you look at the top row of the chart, unpublished materials like correspondence get a longer term of protection. It's the life of the author plus 70 years. That means you have to add 70 years to the year that the creator passed away, and only then does the item fall into the public domain. That gets longer with unpublished anonymous or pseudonymous works, works made for hire, unpublished works when the death date of the author is not known. That these protections I think are often the ones that we're most concerned with, particularly when we're trying to work to digitize collections of letters, correspondence, diaries, that sort of thing. Another aspect of copyright or public domain definitions in copyright is the copyright of the owner published the work without a copyright notice. We talked earlier about how copyright law has changed over time, and that from a 2017 standpoint, periods of time in the 20th century become particularly important for additional review. This period between 1923 and 1977 is a key period where copyright owners were required to put a copyright notice on a published work to claim copyright. This is the common C in a circle symbol that we're all very well familiar with. So if an item published between 1923 and 1977 does not have a notice, it is in the public domain. As a note, the copyright notices generally both have the word copyright or have the word copyright or the copyright symbol followed by the name of the copyright holder. This caveat extends into 1978 to 1988, but the requirements for registration are more complicated or with more avenues in that period. So that's also a fairly straightforward review period. Number 3, the copyright owner failed to renew copyright status of a published work. And these are for works published between 1923 and 1963. So we can see from numbers 2 and 3 that we may have some overlap. Although if from 1923 to 1977, again, if there's no notice, it's likely that in the period of 1923 to 1963, the owner failed to renew the copyright status. We're lucky that both the Copyright Office keeps track of these renewal notices up to 1950, which is a pretty large period of time in this period, but also that HathiTrust is doing research right now on this period of publication, so that it will help the rest of us work through these questions. Number 4, the copyright owner has deliberately placed or dedicated a work to the public domain using a Creative Commons zero dedication. This means that the creator is waiving their claim to copyright. A copyright holder can choose to do this at any point while the item is under copyright by utilizing the Creative Commons licensing system, and it's the CC0 license that puts the material directly into the public domain. Now, cultural heritage organizations don't commonly use the Creative Commons, the CC0 licensing. It's becoming increasingly used, probably in the last 5 to 10 years. We are increasingly using it in relationship to our metadata as opposed to the objects themselves, particularly with systems like the Digital Public Library of America growing and coming on board. But we do see CC0 licensing a lot on photo sharing platforms and other types of internet deliveries, more public internet delivery systems. Flickr, which I'm not sure how widely Flickr is used anymore, but as a photo sharing system, you can see here in the lower right-hand corner that the creator of this delightful, adorable kitty photo has licensed it CC0. So now that photo could be used in memes, could be reproduced. I could take that photo and create a poster of it and distribute that poster to everybody in my office. I'm sure they'd be delighted. So that licensing tells us clearly that this is in the public domain and that it can be used freely. Number 5, copyright law does not protect the type of work. So in this area of public domain works, this is often means documents created by the federal government and its employees as a part of their work or their jobs for the federal government. These materials are in the public domain. Some states, their state document laws put material into the public domain. Florida law is one of those. So public records made or received in connection with official business of any public body, except those records exempt by statute, are in the public domain. If you are working with state documents or state publications and are unsure about this, thankfully we have great partners over in the state library who are also happy to help vet any material that anyone might have concerns with. So that's a lot of material that has potential to be in the public domain that we may have in our collections and that we could easily start selecting for digitization, knowing that we are perfectly within our rights to do so. I think it's important when we talk about materials, digitizing materials in the public domain, that we should not claim copyright when we digitized content that is when the original is in the public domain. If you've altered a public domain work, which many cultural heritage institutions don't do, if we've taken that image of the kitty and we've made a particularly hilarious meme or used that image in a new poster and we want to claim copyright on that poster or on that digital poster, we could do that, but that image itself remains in the public domain in its original. And really only if the alteration meets the copyright law's qualifications for originality and creativity. So that means that if we were digitizing and say we cropped or color corrected an image or we were using that image in the context of an exhibit, that we have not uh, applied originality or creativity in that alteration, and that again, that image will remain in the public domain. I think that, again, this is important to highlight. Over the course of the last 20 years, this for digitization, you'll see examples all over the internet of cultural heritage institutions claiming copyright on materials that are in the public domain, with the thought that by digitizing and putting it online, that constitutes a new point of publication and a new item, but that actually isn't true. That public domain materials, again, remain in the public domain. And if you've reviewed material and you're still not really sure which of those 5 public domain characteristics apply, or you just still have a lot of questions, there's a great tool out there, the Copyright Genie, that you can access. It asks for some information about material and gives you a really nice grid about the copyrights, information related to copyright status of the material and the rules around that, that can also help enforce documentation, make you feel more comfortable about decisions you may be making about material you want to digitize, and again, give you a platform to move forward, to share all material that you have that's in the public domain and hasn't already been digitized. But what if it's not in the public domain? The good news is there are options. So simply because material is not published before 1923 doesn't mean that it's impossible to digitize, or that you can't digitize it within the framework of copyright. Obviously, option 1 is to wait. Sometimes the strategy, you have some material, maybe it's not published quite before 1923. We've got 2 more years before the year 1923 enters the public domain, we hope, barring any changes, new changes in copyright law. You can look at if it's unpublished material, the creator died before 1945, or the creator has unknown, dated before 1895, which again could be a lot of material in your collection, you're okay. If it's published between 1923 and 1977, there's a good chance that it's in the clear, but that investigation of copyright notices and renewal statuses, as we talked about earlier, is a good way to go. So waiting to gather more information, waiting for 2019 when a whole other year of material enters the public domain can be helpful. When waiting's not really an option, you might pursue seeking permission, performing some due diligence. Due diligence is one of these things in the process that's not a clearly defined or singularly defined concept. This is a sort of chart that can help track stages of doing due diligence for copyright research. Basically, you're trying to find the copyright holder. You're asking for permission when you can, when you've been able to find a copyright holder and connect with them, that you're documenting those efforts, then trying again if you haven't gotten any response to that, and getting to a point where basically you've exhausted all reasonable options for locating the copyright holder and documented the process. So in the case of the example on this checklist, right, if we found a copyright holder, maybe we sent a first letter, there was no response, perhaps that letter was returned to us because of address not found, perhaps we have an email address, so we've sent that, we don't get a response to that, we've sent a second letter, we've sent a second email and we've documented those stages, um, and we haven't received permission, we can put forth that we've done our due diligence, and particularly if those letters have been returned, that puts us in sort of a good framework to move forward with documented due diligence behind us. Um, Again, this may be an area to talk with your institutional legal counsel if you have institutional legal counsel. Certainly, it's a risk factor. Being ignored by a copyright holder doesn't necessarily mean that they're not out there, but you've made a concerted attempt, and so it's possible that the risk is low to move forward if you haven't received a response that says absolutely not. But what if you've tried and you've documented, but you still can't find or identify the author of a publisher of a work? The good news for older materials like photographs and audio recordings, it could be impossible to identify or locate the copyright holder. Certainly, even in published books or unpublished letters, if you can't find the person, that you've entered the realm of orphan works. When there is no due diligence to conduct, beyond identifying that you have no idea who the author or publisher of a work is, some strategies for digitizing and sharing orphan works is to first publicly announce your intention to digitize a known orphan work ahead of a project. Define your criteria when you've conducted an intensive search. Define what that extensive search looks like. So that due diligence chart that we just looked at, it can be as simple as documenting the steps that you're wanting to take in your search to find the creator or publisher of an orphan work. When you've decided how much time and energy and what are in the parameters of those searches, you could consider the type of risk, that in assessment of risk, how the work will be used, how fair use comes to play, and then developing reasonable takedown notices. So that although takedown notices aren't legal protection per se, they are a demonstration of an institution's good faith. So if you went through your due diligence, if you felt comfortable that there was low risk in digitizing an orphan work and putting it up online, you might simply include a takedown notice in the metadata to say, if you are the copyright holder of this material and don't want this up, please let us know. And then if you were to receive that notice from someone, that you would follow through on it. So with orphan works, you can digitize at your institution's discretion. Again, considering your institution's risk comfort level. A lot of institutions do digitize orphan works. Some don't, and that's okay. I think that that's another, as we think about selection and copyright again, helping your institution push the envelope a bit, but also working within the framework of institutional's risk comfort level is a perfectly reasonable space to do digitization. As we've seen, there's so much material in the public domain that we can still make a lot of material available. So I mentioned in the beginning that in that sort of triangulation of purpose of the copyright law, that the user does have some areas to maneuver. Fair use probably being the greatest muscle to flex in some ways in terms of pushing copyright restrictions to their outer edges. There are 4 factors of fair use: the purpose and character of your use, the nature of the copyrighted work, the amount and substantiality of the portion taken, and the effect upon of use upon the potential market. Fair use is another one of these gray areas. It's not codified in a way that gives us really definitive definitions of purpose and character, or amount and substantiality, that these 4 factors have been confirmed and defined through case law, most recently the case against Georgia State, and that most of the decisions are actually more in favor of fair use, which is a great thing. So in terms of judging this, right, if in terms of purpose, if it's not for profit or a transformative use, as opposed to commercial or simply duplication, the nonprofit transformative use could fall into fair use. If the material was factual, maybe we're using just a small amount or digitizing a small portion of the material, and it doesn't hurt the market for the original. If all 4 of those factors are along those lines, then it is fair use. If any of the factors are in the no column, then that suggests that our use of the material is not fair use. Use cases that set up fair use guidelines often can get tested in court. As I said, it's not law. Cases are drawn on a case-by-case basis. But to date, when it comes to cultural heritage institution digitization, when people have used these 4 factors for fair use to digitize material, there are, I think to date, 0 cases where a cultural heritage institution has been found to be in violation of copyright law. As an example, from our work here at FSU, we're working through risk assessment and fair use assessment of digitizing a large collection of newspaper clippings, so that from around the country, and these clippings are all specific to a particular topic. We wouldn't be digitizing all of the newspapers, and so far in this fair use check, we feel as though we are moving in the right direction to make a fair use case, since we wouldn't be hurting the original market for the original newspaper, since relative to the original content of the original newspapers, 1 article a piece is a small amount relative to that original, that they are sort of factual in nature, with the caveat that newspapers try to be as factual as possible, and that it is a non-profit and transformative use to do digitization around a specific topic in this case. So this fair use factors can be very helpful in determining how to move forward with projects of material that are actually still in copyright. With risk assessments, again, talking with your managers, with deans, directors, with institutional legal counsel, sort of working from there, providing them with the information for the framework that you want to move forward with. So I think one important element of talking with managers, directors, and legal counsel, not everyone is very familiar with digitization in cultural heritage institutions, and they may be more risk averse because they're coming from, say, legal counsel may be more familiar with patents and other types of intellectual property work, not so much with the parameters of the work that we're doing in cultural heritage. So bringing information forward about what you want to do, the steps that you're taking to review material, to document your due diligence, the risk that you've assessed in this material, and presenting that information to others in your institution can be also a good beginning space to assess that risk comfort. There are organizations and institutions that, despite that, are very risk averse. but others are less cautious. And I've been in conversations with legal counsel um, multiple times, and I think the the more information I can bring forward about our intent and our due diligence, the less risk averse our legal counsel or legal counsel I've worked with in multiple institutions has been. And so I think that's a good element in your overall strategy for selection and information gathering. I think it's also important to say that when it's appropriate, and again, gauging that appropriateness based on the kind of material that you want to share with the broader public in a digital environment, the appropriateness within your own institution and your institutional framework. But when appropriate, try to push the envelope. I think not being pinned in by concern or anxiety, especially when it comes to the unknowns of copyright, or not feeling as though you've been able to document absolutely everything that you want to be able to document, or a question seems particularly complicated, to push ahead and to push the envelope in helping others who make decisions with you understand the need to do this. Obviously, letting common sense prevail, and particularly with orphan works, consider posting them, digitizing them, sharing them, and exercising fair use. And my sort of basis for coming back to this, or really emphasizing this, is if we're not looking out for the needs of our patrons, who will? Often institutional counsel is, I mean, their job is to protect the institution. I think in our work in cultural heritage institutions, part of our job, and a very important part of our job, is to look out for the information needs of our users and our patrons, and to help push the boundaries of copyright application when we can. So some of that common sense, thinking through likely sources of pushback. So for example, content related to highly visible public figures produced by famous people. We're not as inclined at Florida State University to digitize materials, say from Life magazine, or materials that we know the estates of famous people are interested in, that might be, if we really wanted to publish that or digitize that and publish it, we would perhaps spend more time working with estates or legal entities of those public figures. It's also important to be mindful of privacy issues with the content, which is different than the legal issues. So in terms of privacy issues, if there were particularly intimate family portraits, or we're working with materials, images, content associated with protected populations, small children, inmates, we'd want to assess those and sort of the ethics around privacy, that we may have the copyright permission to do so, but we may want to exercise some common sense and not do that. I know often, particularly in universities or schools, there's a question related to privacy that often comes up in digitization of yearbooks or other student publications, which is a fair question to ask. I think and again, this is a common sense sort of risk assessment. If the material was published and widely distributed, then the concept of privacy may lessen in that case. So a yearbook photograph that already had a distribution to hundreds, if not thousands of people, is a much less private item than an intimate family portrait. We just had a case the other day where we have a collection that contains nude photographs. So those will not be materials that we would choose to digitize, because they weren't done as art. But that's another story for another day. The things you find in archives. So you've gone through this process. You've determined the right status of a work. You're ready to digitize. So we'll jump into some of those access and rights statements here in the last few minutes. Before I do, are there any questions that are jumping out for people around those different steps in and strategies in assessing copyright status? I see Francis is typing, so there are a couple other people are typing. These might be long questions. Typing does take a little bit of time. Francis asks, would I consider archive.org already in the public domain? That is a great question. Look something up right now. So if it's on the Internet Archive, or if it's in archive.org, the fact that it's in archive.org and that the Internet Archive is sharing it does not automatically make the material public domain. Again, all the material that's in the Internet Archive has been assessed. The same factors would be shared so that the publication or the sharing of information in the Internet Archive is not in and of itself a transformative process. So each individual item shared through the Internet Archive would have had its copyright assessed on some level, and you would go into some of the metadata to find that out. Annette asked if the slideshow will be available for use later. Yes, absolutely. Swiftland will publish this on site. It is a lot of information to keep track of, so these will be available at the end. And I see Mary is also typing. I'll move ahead in some of my slides and come back to your question when it's there, Mary. So related actually to Francis's question about archives.org, oh, I'll pause for a second. Mary asks, would items donated to the library have an expectation of privacy, personal papers, etc.? Mary, this is a great question. So not necessarily. I think one element I haven't gone over, when materials are donated to a library, and particularly if they're personal papers or the collections of individuals, families, or organizations or agencies, really those materials should be governed by a contract called the deed of gift. Within a deed of gift, the language, ideally in the 20th century or 21st century, we should have statements in our deed of gifts that pertain specifically to digitization and broad sharing, so we get a better understanding of what our donors would like to see happen with material, or if they would prefer certain privacy rights. And that expectation in that donation, really on the part of libraries, we should never have to guess at that. We should have contracts that help define those restrictions and other elements. If in process a library has not executed a deed of gift, or there's no formal agreement between a donor and the libraries in terms of the disposition of those personal papers, if you have contact with the family or the donor, you can always ask for clarification of that. I think in most cases, the expectation of privacy is diminished a bit. And certainly I think it would depend on what the shape of the library really is. So for instance, at Florida State University, we are a research library, and it is a public expectation that materials donated to FSU libraries, special collections, that we're doing that with the understanding that materials will be shared with researchers. In that case, the basic expectation of privacy is diminished or non-existent, that a donor has given us that material um, to be shared. Whether it's been given to be shared on the internet is a more complicated question, but again, um, all the parameters that we've just talked through, even with unpublished works in personal papers, can help assess that situation. So I hope that helped a little bit, Mary. So back to Francis's question about the Internet Archive and whether material on archive.org is already in the public domain. This is where your metadata can become so important and helpful. So if you've determined that you can digitize something, you've digitized it, you're working to share it publicly, you want to clearly and concisely state in your metadata what the right status is and whether or how it can be used. So that's sort of two parallel elements. That right statements communicate the legal status of an item. This is in the public domain. This is under copyright. But access statements can communicate how to responsibly use material. And the Creative Commons licensing can help with that immensely. So to sort of illustrate this point, let's look at a few examples. So let's see if we can find enough information to know whether we can use images on our website. So here's an example from the Minnesota Digital Library, the St. Cloud University Archives. This is a letter from Sinclair Lewis to Marcella Powers, January 1942. We see in the right statement that this is copyright 2009 J.P. Morgan Chase, the estates of Sinclair Lewis. This image may not be reproduced for any reason without the express written consent of the estate. So reuse and reproduction of this, it's not as open, it's not as freely available, but it's clear that you need to contact St. Cloud University, that the estate will be negotiated with to digitize a single copy, but we don't have specific information. There's no actual contact element, so it could be confusing for a user to figure out exactly what to do or how to use this image. Here's one, Romeo and Juliet. This is from the University of Illinois at Urbana-Champaign. If we look at that right statement, Rare Books and Manuscript Library, for questions regarding these materials, please contact the Rare Book and Manuscript Library. This gives contact information in the right statement, but there's actually no real information about what the copyright status is, what a user can or can't do, and it creates a situation where someone has to be available at a permissions desk or to field requests, even if an item is potentially in the public domain. Here we have a photo of Leslie Jones. This is, we see in the rights, copyright Leslie Jones. This work is licensed for use under Creative Commons Attribution Non-Commercial No Derivatives License, CC BY NC ND. This is a self-portrait. We can see that Leslie Jones does still hold copyright for this image, but the Creative Commons license helps us understand what we could do with this item as long as we use the item non-commercially, we attribute it to Leslie Jones, and we don't make derivatives. So this item has those two important pieces of information in the rights field, both the rights assigned to this information or to this object and how people can use it. These are some examples from our own Florida State University digital library with good intentions over the years in rights statements in FSU's digital library. I think we have 67 different rights statements throughout the collection. So our good intentions could very well just add to confusion. We have very long statements. There's a lot in there that's, for more information, please contact so-and-so entity, with no actual contact information of like how do we contact Florida State University. Um, there's some incorrect information in terms of that third bullet point say that all requests must be submitted in writing to the director of university libraries. That's no longer true. That policy has changed, but our metadata was not updated to suggest that. That fourth statement, this item is the property of Florida State University. For more information about copyright, contact special collections and archives. The question of the relevance and property towards right statements and whether that's an accurate statement is one that is under review. So, in the 20 or so years that organizations have been digitizing materials, and in the all the intervening, in those intervening years, all of the variant advice and questions related to right statements, I think, have perpetuated confusion and a lot of good intention that has ended up with just statements that aren't particularly useful to our users and ultimately to us. I think to even understand what it is that can happen over time with material. So the best practice is to include an access statement with your right statements, to work in your metadata to help your users understand what they can do with content on and offline, so that when a student encounters material in your digital library and wants to know whether it can be used in a paper or published online on their website, or an author is trying to figure out can an image or an object be used in a publication, the easier we can make it for our users to do the work that they need to do, the better. Again, it's that advocacy for our users. Something that's recently been developed that I think helps to this end, the Digital Public Library of America. Is everybody familiar with the work of the Digital Public Library of America? If not, I believe there'll be a webinar in September that will talk more about DPLA and participating in these kinds of national aggregate systems. They've developed something called rightstatements.org. These are 12 standardized right statements for use in online cultural heritage. There are 4 statements for material that's already in copyright. So again, these are those use statements. The material is in copyright. That's its right status. Educational use is permitted, non-commercial use permitted. We have an unknown rights holder, so we can't connect you with them. The EU or orphan work is a different set of parameters. These are use statements that are meant to be integrated into digital library metadata. There's a great website, that rightstatements.org has comprehensive information about when and how to apply any of these for material in copyright. We also have in rightstatements.org notices for material that's not in copyright but may have other restrictions. So these restrictions could come through that deed of gift. It may be other types of contractual or legal restrictions, that there's a limit, say, in the deed of gift, that it can only be used for non-commercial use. There are some materials that might be out of copyright in the United States, but in international copyright may be in copyright. And then the statements of last resort are those rights and use statements related to when copyright's not evaluated, when we have an undetermined copyright status, and no known copyright. I say that these are the statements of last resort because obviously you want to work as best we can to digitize and share material whose status we comfortably understand and can share. But when we can't, these are statements that could be used. The benefits of using these, clear statements for users, easier to update centrally. These are URIs, so as information changes, the information behind rights and use can be updated automatically. Rightstatements.org is an emerging standard that has been newly developed, but is being implemented more and more. If you participate in aggregators like the Digital Public Library of America, our statements will align, and users ultimately will have a clearer picture. So I hope this information has been helpful today to think about, again, strategies and processes for determining copyright status and risk comfort, so that we can digitize more materials, that we can describe the rights and access policies related to those materials, so that ultimately we can do what we do best, and that is to connect users to information, to items, to help them learn and create new. And I realize that we're just about 11:02, so thank you very much for holding on to the end. Um, Margarita asks if we have examples of institutions using rightstatements.org. We do. University of Miami has. I can, if they're not added in my resources section on the slides that'll be posted, I will add those examples. And we'll also, again, be talking more about that in a webinar in September. So thank you everyone for being here today. I appreciate it, and I look forward to seeing you, so to speak, in future webinars for SwiftLearn. I hope everyone has a wonderful day.
And thank you, Katie, for a wonderful webinar. Some information and a sneak peek of what is coming up. Attendees, if you enjoyed this webinar, please join us on Thursday, September 7th for digital library collaborations and partnerships. Also, it's not too late to register for tomorrow, Friday, July 21st webinar, H is for Hidden Barriers, Workplace Success Through Inclusion. We encourage you to look at the upcoming webinars and workshops in months ahead and hope you're all able to join us for future training opportunities. As always, please feel free to keep checking the SwiftLearn CE calendar, the SwiftLearn Facebook page, or look for your message from the Florida Library listserv or SwiftLearn listserv. Thank you all for attending and have a wonderful day.